Okay, now let's discuss the issue of racial discrimination engaged in by a state actor or by a private individual or a private enterprise. First, let's look at this issue of racial discrimination engaged in by a state actor. For example, if you go to a governor's office to apply for a job, and then the governor's office would say, we are not going to take your job application because you are from an ethnic minority group. If the governor's office would do this, would that be in violation of the Constitution? The answer is yes, because that will be in violation of the 14th Amendment Equal Protection Clause. Governor's office, no question about it, is a state actor. So if the governor's office would discriminate on the basis of race, that is going to be in violation of the Constitution. Similarly, if you apply for a state university, and then the university would say, we are not going to take you because you are from this ethnic minority group, that would also be in violation of the 14th Amendment Equal Protection Clause, because as you can see, in this 14th Amendment, and it says very clearly, no state should deny any person within its jurisdiction the equal protection of the laws. All right. So we know a governor's office or a state university, either one of them is a state actor. So if they are engaged in this racial discrimination, that will be in violation of the 14th Amendment Equal Protection Clause, because indeed they are state actors. All right. And then next, we need to see if a state actor cannot discriminate on the basis of a race, can a private business owner discriminate on the basis of race? For example, how about a hotel owner, a discount store owner? Okay, can they discriminate on the basis of race? If you come to a hotel and then the hotel owner is going to say, we are not going to take you because you are from an ethnic minority group, or a discount store owner would refuse to serve you because of your race, would that be in violation of the law? The answer is yes, it is also going to be in violation of the law, but of course, their conduct would not be in violation of the 14th Amendment, would not be in violation of the Constitution, because they are private individuals, they are private business owners, they are not state actors. So their action would not be in violation of the Constitution, but their action will be in violation of the Civil Rights Act. All right. So to sum up, if a private business owner would discriminate on the basis of race, their conduct would be in violation of the federal law, that is the Civil Rights Act, but would not be in violation of the Constitution itself, because as we said, only a state actor can have this issue of violation of the Constitution. All right. So now we know the federal government indeed passed this Civil Rights Act, and then we need to come to an issue we have already discussed. That is, the federal government can only exercise the powers enumerated in the Constitution. So if the federal government would like to pass this Civil Rights Act, and then the question we need to ask is, under which enumerated power can the federal government pass this law? Okay, that is always going to be a question. That is always going to be a question that is going to be asked. Okay, under which enumerated power the federal government can do something. All right. So in this case, we're talking about this Civil Rights Act, and then under which power the federal government can pass this Civil Rights Act. Okay. Of course, maybe we just look at this. Maybe we can just say, okay, the federal government can pass this law under the Commerce Clause, under the power to regulate interstate commerce. Okay, because an argument can be made. Business operation is in the stream of interstate commerce. Okay, take this hotel operation, for example. The food supplies in the hotel, they are going to serve milk, they're going to serve potatoes, they're going to serve vegetables, they're going to serve eggs. So those food supplies could be from different states. So that would place them in the stream of interstate commerce. Okay, of course, their furniture and also sheets and towels and those kind of things could also be from other states. Hotel guests could also be from different states. All right, maybe someone would be from travel maybe 2 or 3 states and to reach that particular hotel in a state, and then because this travel of this guest, and then that would also place this hotel operation in the stream of interstate commerce. All right, a discount store, that is the same thing. The goods sold over there could be from different states. So the argument is because this business operation is in the stream of interstate commerce, so under this Commerce Clause, Congress can pass this Civil Rights Act to say no discrimination on the basis of a race, of course also on the basis of religion and national origin of nationality and so on and so forth. And then Congress just under this Commerce Clause, under this power to regulate interstate commerce, Congress argued it can pass this Civil Rights Act. Okay, so as we can see, this Commerce Clause is a very important clause. All right. Commerce Clause is a very important clause, but this clause is also very controversial. We have this concern over this overly broad interpretation of the Commerce Clause. All right. You remember we discussed already. We said, can the federal government pass a law to regulate school curricula? We know if you go to these powers, this list of enumerated powers, and we could not see anywhere indicating the federal government can do that. All right, so we already said it. In general, we say the federal government cannot regulate this school education, and how the education is going to be regulated, that power should be the power of the state, because we did say whatever the powers that are not enumerated in the Constitution should be reserved to the states. So that power to regulate school curricula is not over there, so that power should belong to the state. Not the federal government cannot step in to exercise that power. All right, but the issue is if you make this overly broad interpretation of the Commerce Clause, if you want to argue, these food supplies in this school cafeteria, they could be from different states. Yeah, that's for sure. And if you go to this school cafeteria and you eat this eggs and potatoes and whatever other vegetables, and they could be from different states. And students' textbooks and school furnitures and school supplies, they all could be from different states. So if you argue because of this food supply, textbooks, and so on and so forth, they are in the stream of interstate commerce, and then the argument can be made that the federal government can regulate school operation. Meaning is, the federal government now, based on this broad interpretation of the Commerce Clause, the federal government can actually step in to regulate school curricula. See, that is really the concern, because according to the Constitution originally, and this power to regulate school regulation, to regulate this school curricular or this school education in general, that is really the power that should be exercised by the states. But now the federal government is going to come in to regulate this school education based on this broad interpretation of the Commerce Clause. So what is the concern? The concern is, this federal government is going to become so big. The federal government is going to take these powers away from the states. And that would be that would not be consistent with this original design of the Constitution, because once again, it's important for us to emphasize this point. Originally, we did say whatever the powers that are not enumerated in the Constitution are reserved to the states. Now, you cannot, based on this overly broad interpretation of the Commerce Clause, you want to grab these powers from the states, and then the federal government wants to exercise this power. So that is really the issue. That is really what we mean by this concern over this broad interpretation of the Commerce Clause. All right. A particular example, actually a very important U.S. Supreme Court decision, is this United States versus Lopez, the decision made in 1995. The issue in the case was this constitutionality of this Gun-Free School Zone Act. Okay, Congress passed this law. And according to this law, anyone would bring a gun, carry a gun within 1,000 feet of a school. That would be a federal crime. Okay, we should all understand this school violence, and especially this gun violence, is a serious problem, and this problem certainly should be regulated. But if the state government wants to regulate, it is okay. But now the federal government wants to regulate this gun possession in a school zone. Can the federal government do this or not? So now we need to ask this question now should be familiar to you already. That is, whenever the federal government wants to do something, it has to go to this list of these enumerated powers to point out under which power it can pass this law. All right? And then under which power Congress actually passed this Gun-Free School Zone Act. No wonder Congress went to the Commerce Clause. All right? Basically, the Congress made two arguments. It says this possession of a firearm in school zone may result in violent crime, and violent crime will affect functioning of the national economy. Okay, the first one is cause of crime. Of course, if we have a violent crime committed, and then there would be cost of crime. And the second one is this gun possession, gun violence in school would also affect this national productivity. If we have this gun violence in school, students cannot learn properly. And then by the time they graduate, they cannot really contribute to the national economy. So, of course, that would affect this interstate commerce. All right. Actually, it could also be argued this school operation is in the stream of interstate commerce because the textbooks, food supplies, desks, chairs. So you know that argument. So based on this argument of a Commerce Clause, Congress said it has the power to pass this Gun School Free Zone Act. All right. But of course, later we need to see how the U.S. Supreme Court ruled on this constitutionality of this gun school free zone act.